Hello and welcome to Chapter 5, which will be on substantive and procedural law in the four different legal traditions. You recall from earlier chapters that when we're talking about substantive law, we're interested in identifying what is criminal and what the punishment is. And every country needs to do this. Under any legal system, you have to have a way of identifying what kind of behavior is either required or prohibited, and then explaining what's going to happen to anybody who either doesn't do what's required or does what's prohibited. And this, of course, is substantive criminal law. Substantive criminal law differences are found among the various legal traditions, but those differences are not as dramatic as what we might think. You'll recall from Chapter 3 that we discussed substantive criminal law in two different ways. One was to refer to its general characteristics, things like politicality, specificity, uniformity, and penal sanction. There really isn't going to be much variation among the countries in these characteristics. Pretty much every country, every legal system, regardless of legal tradition, has general characteristics that at least strive toward or claim to strive toward these four general characteristics. We find a little bit more differences in the major principles of substantive law. And again, you'll recall from Chapter 3 that those include mens rea, actus reus, concurrence, harm, causation, punishment, and legality. We can't go through each one, but we can identify a couple just to show how some of those differences might be described. Let's take criminal responsibility, for example. In each country, and by the way, while I'm thinking of it, when you're doing your term paper, this area is a particularly good one for developing particular items about which your various countries can be compared, looking at how your three countries differ in terms of criminal responsibility, or, as you'll see in the next column here, insanity defense, provides an interesting way to do those comparisons. So maybe think about that as we're going through these next few slides. So back to criminal responsibility. In Germany, the law says that if you're under age 14, or if you're acting in self-defense, you cannot be held criminally responsible. Now this, of course, is the defense of immaturity and the defense of self-defense, which we find in the United States as well. And in fact, in most countries, you'll find that there is some distinction regarding criminal responsibility and identifying particular groups or characteristics that people have that would exclude them from that criminal responsibility. Islamic schools of law provide a little bit different variation because most of the countries, in terms of age of responsibility, will use chronological age. Under some Islamic schools, puberty is used instead of a specific age. The belief that once a person, male or female, reaches puberty, that is an indication of responsibility. And it makes about as much sense as using a particular age. It's just that most of the legal traditions, most of the legal systems use that chronological age instead of some biological characteristic. So under the Islamic schools, it's not possible, under most of the schools, to be criminally responsible until you've reached the age of 7. And then between the ages of 7 and puberty, there is seen as being some partial capacity for criminal responsibility for some types of crimes. And again, we see this in many of the other countries of the world where you have a minimum age of criminal responsibility, which might be 7 or 10, and then an age at which juvenile court jurisdiction stops, which might be 17 or 18. And then there's oftentimes a distinction between ages 7 and 14, for example, when, depending upon the crime that's been committed, a person is said to have partial criminal responsibility. Much of that, of course, is done for political purposes, being able to respond to an individual who's committed a heinous crime even though the person is under an age of that most people would otherwise think as being not able to have criminal intent. Insanity defense provides another interesting variation amongst the different countries and legal systems. Just a few examples here. In Finland, you can use the insanity defense if you have mental deficiency or temporarily without mental faculties. In Germany, insanity is referred to more as an individual who can't appreciate the unlawfulness of his or her actions, or might act as a result of a mental abnormality. That one, of course, is very similar to what we have in many of the United States, where state law provides for these same kinds of insanity defenses. Nigeria, insanity under Nigeria's law is you can't understand or control your actions due to a mental disease or infirmity. Again, similarities to what we would find in many of the state laws as well. So that's why I was saying earlier that you aren't going to have very much in the way of dramatic differences in terms of these particular aspects of substantive law, but it does give you some interesting ways to see how other countries might, in this case, define insanity. And it's kind of I guess in some ways comforting to know that other countries have as much difficulty in coming up with a good definition of something like insanity as we do in the United States. When we look at substantive law more generally, we can make observations regarding the common legal tradition. And it's a good time to remember a distinction between written codes and unwritten law, which common law and custom is said to represent. The part that gets a little bit confusing here is that we all know that the common legal tradition in the United States and in the individual states, we have written laws. We have codes, in fact, make reference to things like the California Criminal Code, for example. So one wonders why we call a legal system like California's or some other place a common legal tradition or common legal system when they have written codes or written statutes. And the key distinction here is the way that these written statutes are perceived. Again, reminding you from chapter 4, under the civil legal tradition, when a law is put into writing by the ruler or by the legislator, that's what makes it law. That's the source of law, that codification. Under common legal tradition, you can write something down, but that's not what makes it law. It's the custom, it's the precedent, it's the history of that behavior and the way society responded to that behavior that makes it law. Another way of looking at it is that under a common legal tradition, when a law is put into writing, it's not seen as being revolutionary. Under a civil law tradition, by putting a law into writing, or putting a law into a code into writing, it is revolutionary in the sense that it can be overturned by the next grouping of legislators. In Italy or France, for example, you make reference to political changes or constitutional changes in terms of when the Constitution has been revised. And in doing so, you can make reference to when the most recent version of the criminal code has been upset or changed. An example would be that if in Italy or France or some other civil legal tradition country, the legislators decided that they were going to dramatically change the law of theft. This wouldn't happen, but pretend for a moment that it might. Well, since the source of law is that code, you could be revolutionary in the sense that you take what used to be a definition of theft, and the current group of legislators or parliament decides that this is going to be the new definition of theft. Well, because the source of law is what the legislators say, and not something based in custom, then presumably the French and the Italian citizens would accept this new definition as being the way the theft needs to be defined. The law or the code is revolutionary when it is written down in that sense. The common legal tradition, again, the writing down of a law simply reflects custom. It isn't the source of law itself. Pardon that elaborate definition, which I hope provided some clarity. So back to the common legal tradition column on your slide. Here we have, for example, typically states would set up different levels of crime, making reference to felonies as being the more serious, misdemeanors the less serious, and the petty offenses as being that are of even less serious nature. And we determine seriousness based upon not only the type of crime, but we also attach certain punishments to it, so that felonies have more severe punishments, misdemeanors and petty offenses less severe punishments. In a civil legal tradition, using France as an example, the French Penal Code is broken into 5 different books, and each book identifies particular types of offenses and what the punishment for those offenses are. The example on the slide is that one book has general provisions that make reference to things like criminal responsibility. Another book describes crimes against persons, and yet another book will be describing crimes against property. So each book of crimes, or in the penal code, each penal code book addresses a certain aspect of substantive criminal law. But again, not too much difference in terms of how we would describe common and civil legal traditions. The example of theft is where we, or does provide a situation in which we do see some differences, and it's an interesting one. Your textbook describes these differences as well, using Colorado as an example of a common law state. The law in Colorado as it reads, and I'm on page 121 of your textbook, a person commits theft when he knowingly obtains or exercises control over anything of value of another without authorization or by threat or deception, and then it goes on to list 4 kind of subsections, things like intends to deprive, uses, conceals, or abandons, demands any consideration not legally entitled, those kind of things. So it's a very, very specific type of law. And it seems a little bit strange because if we're basing this on custom, you would think that you would just have some kind of a statement about don't take something that doesn't belong to you. Well, in fact, we find that kind of statement more typically in the civil law tradition. Germany and France, for example, they rely upon very general principles and basically do say theft is something when you take an item that doesn't belong to you. For example, on page 122, I'm reading the French law on theft, Article 311-1. Theft is the fraudulent appropriation of a thing belonging to another person. And that's pretty much it. So we have a situation where the common law feels the need to be very, very specific, trying to anticipate all the different kinds of consequences or situations in which the law of theft might be violated. The civil legal tradition, on the other hand, leaves it very vague and in some ways almost up to the interpretation of the judge. In fact, we're going to find that this becomes a very interesting way to distinguish between adversarial and inquisitorial systems and common law and civil law, because the inquisitorial judge has a bit more power and influence in terms of the way the trial proceeds and isn't tied in so much to custom and to precedent. It's a bit more up to the civil law judge to interpret whether the evidence shows that a theft has occurred. Under the common legal tradition, the power of the judge certainly is there, but much more bounded by the rules of evidence and whether or not this particular act met all of the requirements as stated in the substantive law. So this is one of the areas where we do see a little bit more of a difference between the legal traditions. Summarizing those, under the common law, the law was originally was defined through immemorial custom as opposed to civil law, where crime is defined through codification. Under common law, the judges and everyone else in the community knew what behavior was acceptable because it was customary. This is the way that it was always done. Under the civil law, however, identifying what was criminal should be easily accomplished. You shouldn't have to go back through custom. You shouldn't have to look at precedents. It should be something that even the average citizen can do. And in fact, again, when we look at the distinction between common and civil judges, we'll find that under the civil legal tradition, becoming a judge is something that you could do pretty much out of law school. Go into magistrate service as opposed to prosecution or defense, and that would just be one of your choices. And that's because under the civil legal tradition, interpreting whether a crime has occurred or not should be very, very simple. You read the statute. If this person took something that didn't belong to them, then presumably the crime of theft has occurred. The last bullet, today the reliance is on statutory law, legislators more so than on judge-made law. But again, I emphasize that we're still linking to custom and making reference to the idea that this is the way things have always been. Under the civil law, the code reflects general principles rather than providing any kind of detailed description. And very quickly, hopefully, we can finish this first part of Chapter 5, and we need to make reference to the substantive law in the Islamic tradition, because it does present a little bit of a difference. We still have types of crimes, felonies, misdemeanors, and petty offenses would be a common legal tradition example of that, or the 5 books under the French Penal Code. But here the crimes are defined a little bit differently than what at least a Western mind is used to seeing them. Islamic law identifies crimes that are hudud or had crimes, using the plural, casus crimes, and tazir crimes. And this is explained more fully in the textbook, but generally speaking, the hudud crimes are those that are decreed by Allah as being criminal. And because they are crimes that God has identified as being offenses, they are seen as being absolute, can't be subjected to interpretation. If a person commits one of these hudud crimes, or one of the had offenses, again using the plural, then these are the ones that are accompanied by very, very severe and harsh punishments because the acts violate God's sanctity and threaten society. Your textbook describes some of the reasons for this and why, for example, things like theft might be punished as a had as opposed to murder, which is a different category of crime. Under Western thoughts, you would include murder as being the most severe and serious offenses, but under Islamic law, serious as it is, and it's not meant to identify it as being any less serious, but it's not seen as being something that violates God's sanctity and threatens society in the same way that an act like adultery or theft might. The casus crimes are those that are like crimes against person and other legal systems. These offenses require some kind of equivalent retaliation, either by the victim or the victim's family. And this can be either a financial retaliation or an eye for an eye type of retaliation. You steal my pig, you have to give me 2 of your pigs. If it's a casus offense, the victim has a good bit of say in what the punishment is going to be, much more so than would be accepted in any of the other legal traditions. And in fact, we'll talk about later, the Islamic tradition is in many ways much more victim-oriented and victim-centered than the other legal traditions are. That last grouping, the tazir offenses, these are crimes that are not mentioned in either the Quran or the Sunnah, and they are seen as being the least serious of the offenses. They've been identified over time through consensus of justices or jurists. They result from the state's right to criminalize and punish certain kinds of behavior. And this is also one of the ways in which Islamic law can be kept current so that you don't have to have relied upon Muhammad as having identified something as being a technological offense, a computer crime. You can have a tazir offense that would be something that is interpreted by the current Islamic justices or jurists, I should say, and also the state has a right to create some of these kinds of crimes and punish them accordingly. So that gives you an idea. Again, your text elaborates on these three, and I think you'll find some of these to be kind of interesting because it does modify a little bit what the common perception is, especially in the United States, regarding Islamic law. We tend to know only about the hudud crimes and aren't really familiar with even why those are seen as being such serious crimes. And we have less knowledge of the casus and tazir crimes. The substantive law in the Eastern Asia legal tradition, this operates from the premise that the tradition's preference is for legal informalism. We try to handle things as informally as possible under the Eastern Asia tradition. In Japan, there is a lack of specificity in such areas as the recognized defenses to crime, the definition of some crimes. We'll see some examples of that when we get into the chapter on Japan. And rather than having any kind of gradation of offenses, degrees of seriousness are made with reference to the punishment. So a crime is seen as being more or less severe based entirely upon the punishment attached to it. The end result is the same as we might have, again, in United States jurisdictions and even in many of the civil law jurisdictions as well. But it just is approached from a little bit different angle than what we're used to seeing. China provides a little bit different emphasis upon informalism, because here not only are the procedures informal, but even the definitions of crime itself is rather informal. Informal in the sense of being rather broad and vague regarding exactly what it is that's prohibited. That ambiguity, of course, allows for some flexibility in how officials respond to that misconduct, and that provides some opportunities for abuse, as you can well imagine. So if we summarize the substantive law in the Islamic and Eastern legal traditions, we would say that under Islamic law there is some similarity to the civil legal tradition in the sense of having crimes that are defined in writing. There are different, the crimes are different from the civil legal tradition, however, because codification, for lack of a better word, is by Allah rather than by the legislators. That is, we have the codes as the result of Allah's dictation. And there are three categories: the hudud crimes, which are those acts violating the sanctity of God; there are casus offenses, which require retaliation by the victims; and there are the tazir offenses, which are categories or crimes that don't fall into either of the two previous ones. Under the Eastern Asia tradition, legal informalism is the preferred way of handling things, and that is best achieved when you have substantive law that is rather vague and flexible. The lack of specificity and this vagueness and ambiguity allows some flexibility in how the law violators are responded to. That completes part one. In the next part, we'll take a look at procedural law differences, following up on this part which covered substantive law. Thank you again for your attention.